So this is dicey ground essentially for Rahul Gandhi. There's a very, very serious threat right now that he faces of being disqualified as a member of parliament. Rajdeep, what do you think? Do you think there's a strong chance right now of Rahul Gandhi being disqualified as a member of parliament? Because that's huge then.
Well, Akshita, there are precisely 3 sections of the Representation of People's Act that deal with disqualification of a legislator or a member of parliament. Sections 8.1, 8.2 and 8.3. 8.1 is for serious offences, Section 8.2 is for relatively less serious offences, and Section 8.3 is for even less serious offences. The sense from criminal defamation for which Rahul Gandhi has been convicted for 2 years would come, I believe, under Section 8.3, where he would stand disqualified under Section 8.3 unless the appellate court not only stays the sentence but crucially suspends the conviction. Rahul Gandhi does have time to go and appeal, possibly to the Gujarat High Court first, and get a stay not only on his sentence but get the conviction suspended. Should that happen, then of course Rahul Gandhi is free to contest. If that doesn't happen, then it is the discretion of the Speaker who will have to go through the judgment and take a call on that. But given the fact that criminal defamation may not be seen quite as some of the other offences under which MLAs in the past and MPs have been disqualified, Rahul Gandhi will hope that he can get a more favourable ruling from a higher court and get his conviction suspended so that he can continue as a member of parliament and contest the next election.
Okay, Rajdeep, just stay with me, because another aspect that this entire issue has brought up right now is the debate over the defamation law. Is it a draconian law? Should it be done away with? All of that has come back to the fore with this particular case against Rahul Gandhi and his conviction. So let's give you a bit of a backgrounder into the defamation law. It was conceived back in 1837 by Lord Macaulay. So it was brought about by the British here in India as well. It was introduced also in 1860 in the IPC first draft. So since the 1800s to today, this law is still very much in place. It's the act of communicating false information to a third party. So this particular act is what leads to a defamation case being slapped against someone, and that's not the only case. It's also of a case of false information that damages someone's reputation, in which case also they can go ahead and move court and file for defamation. It can be redressed with monetary compensation, but also besides a fine, there can also be a jail term of up to 2 years, as you've seen in the case of Rahul Gandhi. The maximum jail term in the case of a defamation violation is 2 years, and Rahul Gandhi has got that maximum punishment. There are 2 types of defamation, of course, civil and criminal. It's largely over criminal defamation that there's been a huge debate on that particular issue. So, taking this back across to Rajdeep, Rajdeep, let's talk about this defamation law. There's a huge debate about it. There's always been for the last many years. Every time there's a case that's put up against someone under defamation, many countries have gotten rid of this law, saying it's draconian and that it's in direct contradiction to one's freedom of expression.
Well, it's interesting. Defamation laws have evolved over times. It is a colonial law in many ways. Criminal defamation in particular is being struck off the statute books in several countries, including in 2009 in the United Kingdom, where it was said that defamation should be treated as a civil tort and not as a breach of criminal law. In India, on the other hand, there was a challenge to criminal defamation, ironically led by none other than Subramaniam Swamy, who's faced a slew of defamation cases against him. He went to the Supreme Court challenging the constitutionality of criminal defamation. However, he lost the case. A number of journalistic organizations and some of us had also joined in that petition. However, the court ruled that under Article 19, freedom of speech, one of the reasonable restrictions was criminal defamation. It did act as a deterrent, and therefore, as of now, it is still very much on the statute books, although a number of critics say it's being used as an instrument of harassment and therefore needs to be struck off the statute books.